So today I will do a general introduction on the asset recovery strategy. I will talk a bit of the interplay of asset recovery and money laundering, why it's important to tackle, to address this issue as part of this seminar. And then I'll make a transversal typology of confiscation models across the EU to understand what powers of confiscation are available depending on the member states concerned. Or it's a general and transversal typology. And then I will talk about the latest EU legislation on asset recovery. This is, say, Directive 2014-42 EU, which covers substantive confiscation law, and the new regulation 2018-1805, which will be in force as of the end of this year, which regulates procedural law in terms of mutual recognition of seizure and confiscation orders. Please feel free to indeed to send me a question within the public chat if you have any during my talk. So as a general introduction, I always love, for those who know me, to start the presentation by giving numbers, especially in the area of white-collar crime. Why is fighting money laundering and why is focusing on seizure and freezing and confiscation of assets that important today? So if you look at the economic snapshots of the criminal activity, criminal economy, you can see a lot of figures that have been published by supranational bodies. The IMF in 1998 estimated that 2 to 5% of the global GDP would be black economy, so proceeds of crime in general. The UNODC indicated in 2029 that this number would be around 3.6%, and that of this amount, 2.7% will be available for money laundering. So that's how much money was channeling through the economy worldwide. The UNODC also said in 2011 that the proportion of laundered proceeds actually seized are close to 0.2%, which already tells you that what we have in place is not working sufficiently. And that's why, and that will be one of the things I will explain during my presentation, that's why member states, but also supranational bodies, have been promoting the implementation of enhanced powers of confiscation that are not the standard criminal confiscation as we all know, but that are either presumption-based or non-conviction-based. But I will get back to that later on. But money laundering is black money that you're trying to give a licit appearance to. If you don't seize that money, well, you don't end up the game of money laundering. So that's an issue. If we look at the EU figures, you can see that in 2013, the EU estimated that 330 billion euros would be laundered per year. That might be an underestimation, though. If you just take at one analysis that was made in Germany in 2016, they assessed that up to 100 billion euros would be laundered every year in Germany alone. Going to Europol figures of 2016, which are quite interesting as well, Europol estimated that only 2.2% of the criminal proceeds would be seized every year, and only 1.1% would be effectively confiscated. So that shows how much the black economy is still working today, and there's not enough hurdles to them. So there's more work to do from a law enforcement and intelligence perspective to fight more efficiently financial and economic crime. So going to the asset recovery chain, because there's a lot of concepts and notions used to talk about the deprivation of criminal property from someone. The general concept is the asset recovery strategy, is all these phases that you have to go through to try to identify at the first place and then confiscate and dispose of the criminal assets. So in a snapshot, first you have asset tracing. The first thing you have to do as a law enforcement authority to try to take away criminal property from someone is first to identify those assets. So you have to launch a financial investigation to collect intelligence, trace, and try to identify and locate the suspected unlawful property of the offender or suspected offender. Then you have to freeze those assets. Freezing or seizing and managing those assets means securing the property. It's a temporary deprivation of suspected criminal property during the investigation, pending trial if there's one to be, and with a view to confiscating the assets. Because if you don't seize at the first place, you will end up before courts ordering confiscation, and you will never be able to enforce those confiscation orders, because criminals are generally intelligent, and if they know they're being charged and they will be prosecuted, they will dissipate their assets. They will hide them. So the first thing to do, as soon as you open an investigation, investigate the assets of the person and freeze, seize any assets that you find relevant from a law enforcement perspective. Then, at the end of the investigation and trial, if there's one to be, there's confiscation. Confiscation is a final order that will order the permanent deprivation of criminal property, which will be either transferred to the state or restituted to the victims. The last phase of the asset recovery chain is the actual recovery and the disposal of the property, because sometimes you will, as I was just saying, sometimes you will order a confiscation order without having first seized the assets. Then you have to enforce the order. So there are instruments to launch a post-conviction investigation to try to find assets that will be taken to enforce the confiscation order. So that's the last phase of the asset recovery chain. So today I will focus on confiscation. I will talk very briefly of freezing, especially within the scope of the regulation on the mutual recognition of freezing and confiscation orders, but I will really focus on confiscation today. So going to the interplay of asset recovery and money laundering. So why discussing asset recovery as part of a money laundering conference? As I often say, money laundering and confiscation are two faces of the same coin. Because basically, the goal of both the money laundering offense and the confiscation instruments is to ensure that crime does not pay, is to go back to the money which was generated by crime and try to take away that money and to criminalize the fact of trying to give a lawful appearance to that money. And what is interesting to note is that both money laundering offenses and also regulatory anti-money laundering laws, which Mrs. Soriano really well explained, is dedicated to preventing money laundering through customer due diligence. And asset recovery, they are part of what we call today the follow-the-money approach. In the 70s, more or less, we realized that it was hard to investigate some types of crime. There's more and more criminal engineering today. So one idea was, instead of focusing on the underlying crime, was to find the money and trace it back to the crime. And that's why criminal offenses such as money laundering were born, and confiscation of the proceeds of crime as well. Because if you look at it, really the birth of the follow-the-money approach and the birth of the confiscation of criminal proceeds and of money laundering regulations and money laundering offenses was the 1970s, the war on drugs and the war on organized crime. It really focused at that time on money laundering or confiscation as part of mafia-type offenses or drug offenses. Then we realized that this was working quite well and that this could be expanded. And so in the 1990s, the follow-the-money approach was expanded not only to cover criminal organizations and the drug trades, but to cover any kind of acquisitive crime, because you can launder basically the proceeds of any crime. Then in the early 2000s, there was a shift of paradigm, or a new paradigm, because until then, we were only focusing on the proceeds of crime, so the benefits, what has been derived from crime. But with the 9/11 attacks and the war on terror, we realized that we also had to focus on the instrumentalities of crime. So not the money derived from crime, but the money that was to be injected into crime. And really, that was a big focus that was added. If you look at it from a preventive regulatory perspective, that's where AML became AML/CTF. So anti-money laundering and counterterrorism financing, not only looking at where the money is going, where the money comes from, but also looking at where the money is going today. And the last evolution that I see is the 2010s, after the big financial crisis that we saw throughout the world. There's really, I would say, war on white-collar crime, where prosecutors worldwide have understood that there's a lot of money involved in those white-collar crime offenses, and they're really focusing on targeting that kind of criminals. So as I was saying, money laundering and asset recovery are, for me, two faces of the same coin. If I want to focus a little bit more on the follow money approach, I would say that it's a triangle. It's a triumvirate. Why? Because the follow the money approach, in my view, has three aspects to it: prevention, criminalization, and deprivation. Prevention is trying to prevent illicit financial flows, detect them, trace, and prevent them through the anti-money laundering regulations. It's the regulatory framework that you put in place to prevent the illicit financial transactions. Then you have the criminalization of illicit financial flows, where you investigate and prosecute money laundering, terrorism financing offense, and also more and more unexplained wealth offenses. So there's a trend, which is not that growing for now, but which exists, towards implementing criminal offenses of possessing unexplained property that you cannot justify. And if you fail to do it, you're subject to imprisonment. And then the third aspect of the follow the money approach is depriving illicit financial flows. So it's to freeze what you think is suspect, and then to confiscate what you prove is connected to crime, whether instrumentalities are proceeds of crime. So the birth of the follow the money approach is the following, and that's quite interesting because this little illustration that I make can be replicated throughout the time. So basically the fight, the follow the money approach was born in the US in the 90s, 80s, as I was saying, with the war on organized crime and war on drugs. And I will give you examples in a minute of legislation on that. Then the American impulse was taken by international law, so the FATF and the UN, which adopted convention that was replicating the US model, meaning creating a regulatory framework for anti-money laundering, criminalizing money laundering, and requiring member states or the global community to adopt confiscation laws targeting criminal proceeds. And that was in 1988 and following. Then at European level, broadly speaking, you've had EU and Council of Europe directives or conventions as soon as 1990, which is interesting as well, because you see the correlation is only 2 years before that was integrated into EU law. And then national law, if I just take Belgium in 1990 already implemented the EU law covering money laundering, confiscation, etc. Here you have the better example of it. I give you the parallel between the anti-money laundering laws and the asset recovery laws that were adopted based on the structure I just explained you. You can really see a correlation between the implementation of money laundering offenses and the confiscation of the proceeds of crime. For example, if I just take the UN Convention of 1988 on the fight against drug, well, that convention required members of the international community to implement a criminal offense of money laundering. That was in 1988, money laundering of the drug proceeds, and it also required those members to implement the confiscation of the proceeds of the drug trade. So you see, it was really correlated, and that's why I'm saying that they're really two faces of the same coin. Because in the end, when you have criminal trial for money laundering, at least in Belgium. When you're prosecuting a money launderer, what is really feared is not jail time. Belgium is maximum 5 years, and money launderers don't often spend a lot of time in jail anyways. It's not the criminal fine, because criminal fines are not that heavy in Belgium. What is really feared is the confiscation of the criminal proceeds. In the case of money laundering, the whole chunk of money that has been laundered. That's really what we're looking at, and that's really what could be of interest in money laundering cases. So that's why the correlation between both is really important today. Having said that, I'm now going to focus on confiscation models, and I'll give you a sample of the transversal typology that I can see across the EU and even the Western jurisdictions today, if I look at the US, for instance. So the departure point, when we think, and please tell me if you have another view, but when we think about confiscation of criminal property today, we generally think of, well, I'll say standard criminal confiscation. So it's a permanent deprivation ordered by a court of law as part of a sentence of the offender, either as a penalty or as a security measure, after their conviction, obviously, and the burden of proof is quite high, because you have to secure the conviction of the person beyond a reasonable doubt, and then prove the nexus between the property and the offense for which the person was convicted at a certain level, medium to high, depending on the country that is involved. That's standard criminal confiscation. The problem with it is that it's quite costly, lengthy, and requires high standards of proof. So it has proved little efficient, little effective in practice, because you first have to secure the conviction of someone, and then you really have to prove the nexus between the property and the crime. So basically, what has happened since the birth and expansion of standard confiscation was to try to expand confiscation powers in Europe and in Western jurisdictions in general, to try to have something more efficient that works a bit better. So there has been a lot of ways that have been imagined to try to expand modern confiscation powers. Basically, if I make a summary of the different features that are the most commonly seen, confiscation is generally a judicial order, but sometimes it can work outside of the judicial system. It can be conviction-based or non-conviction-based, so it's possible to confiscate criminal property without having the conviction of a person. I will talk about it a bit later, because it's a very hot topic today. You can have confiscation through criminal, civil, and or administrative proceedings. You can have confiscation powers that include the use of presumptions or not presumptions, etc., etc. So there's a whole wide net of confiscation powers, which are quite different and difficult to understand, because I will say that, and it's a bit of a stretch, but there's almost as many as confiscation powers and structures that you have member states in the EU. So it's important to try to harmonize those powers to ensure a better cooperation and efficiency of fight crime across the EU. That's a premise to a talk I will make later on the substantive EU legislation on confiscation. So I'm sorry, because the format of the PowerPoint has a bit moved while uploading. Basically, I'll try to simplify my points. I see now 2 to 3 overarching powers of confiscation: judicial conviction-based confiscation, what I would call criminal confiscation, and judicial non-conviction-based confiscation, what I would call civil confiscation. You also have non-judicial confiscation, which is what I would call administrative confiscation. That's how they would call it in common law countries. I acknowledge that in Italy, what they call administrative confiscation is actually civil confiscation, because it goes through courts. I will not discuss much more non-judicial confiscation in the following slides, so I'll just give you an example. In the US, and to some extent in the UK as well, it's possible to seize the property of a person. For instance, you have a police officer that's doing a traffic route control, opens the trunk of the car because of suspicions, sees a duffel bag with money in it, takes it and says, okay, I have suspicions that money is connected to crime, so I will seize it. Here's your notification. If you don't challenge that order within the next 30 days, then your money is definitively gone. And so confiscation of suspected criminal property occurs by the mere passing of time after notification of the intent to confiscate. That's a really sweeping and broad power in my view. That's a power that's extremely used in the US and leads to a lot of problems in practice. But I just wanted to make you aware of that, because we see that confiscation powers are expanding, and there might be a risk that there might be a new trend soon to adopt non-judicial forms of confiscation, which obviously I reject from a personal point of view. So going to conviction-based and non-conviction-based confiscation, basically the two more important confiscation regimes that we have are conviction-based and non-conviction-based through judicial proceedings. Within each of those models, you do have specific powers to target either specific property or unjustified property. I will make it simple and try to explain what are the most popular conviction-based confiscation models today, and then the non-conviction-based confiscation models. As I told you, what we generally see in all member states is standard confiscation. I just explained what it is. I will not go back to that. But what we have observed in the last 10 to 20 years, and it's now a requirement at the EU level, is to implement what we call extended confiscation. So extended confiscation is a conviction-based confiscation. So it still requires to have the conviction of a defendant. And then once we have that conviction, we can target his or her unexplained wealth. So basically there will be an investigation that will be made on their wealth. If there's a disproportion between their legal income and their wealth, there will be a presumption used to some extent that the disproportionate assets are of unlawful origin, and if it then will be up to the person to explain the origin and to try to justify the origin. So that's interesting because that model extends the net of confiscable assets based on the presumption that the unexplained wealth of the offender is unlawful, or the convicted offender, and there's really a sharing of burden of proof between the prosecution and the confiscation subject, the convicted offender. So as I was saying, it's now a legal requirement. It's mandatory under EU law for member states to have extended confiscation within their domestic order. These are the two most popular conviction-based confiscation models. But now what we're seeing as well are two increasingly popular non-conviction-based confiscation models. It's a growing trend. It's not yet mandatory at EU level, but there's more and more countries implementing it. I will give statistics later on that, and it's important to understand what that means. In their purest forms, I will call them civil confiscation and unexplained wealth orders. So civil confiscation allows law enforcement authorities to go before generally non-criminal court, civil or administrative court, to target criminal property. And they do so without first having to prove the guilt of the confiscation subject, meaning of the property holder, because we're focusing exclusively on the property, and we're saying that the property has been tainted by crime. And so that's very interesting from a law enforcement perspective, because as I was saying, you don't have to prove the guilt of the person holding the property, and the evidentiary standard to prove the link between the property and crime is generally lower than in criminal proceedings, because you're in civil proceedings. So you will generally apply the civil standard of proof, i.e. the preponderance of evidence. So it's more likely than not that that property is criminal, so it will be confiscated. So it's very efficient. It's very interesting from a law enforcement perspective. Obviously, it raises a lot of doubts from confiscation subject and individual protections perspective, but the European Court of Human Rights has been very keen to plainly accept that kind of model that has been developed in the UK and in Italy and in many more countries. It does not consider that these confiscation orders amount to the bringing of a criminal charge, that it infringes the presumption of innocence or whatever. So we're free to go with implementing that kind of civil confiscation powers at EU level. It has been discussed. It was originally planned to try to implement such a model in the Directive 2014-42, which I will talk about later on, but it has been then rejected due to too much concerns in terms of protections that model offers. But there's a lot of countries that have that model in their jurisdiction. And the last bit of it is unexplained wealth orders, which you could compare to extended non-conviction based confiscation. So basically what you're doing is not only you have the benefit of going through civil proceedings, but you also use the disproportionate wealth test to implement presumptions, the use of presumptions in the model. So the best example to help you understand is I'm a law enforcement authority. I have suspicions about a person that he might be related to mafia organizations or criminal associates, or he's a PEP. That's, for instance, in the UK, you can rely basically on the fact that he's a PEP. And I will launch a financial investigation of the wealth of the person as a law enforcement authority. And if I see a substantial discrepancy between their lawful income and their wealth, I will use a presumption that these are unlawful assets. And so I will be able to go through a civil court by using the presumption that the disproportionate assets are unlawful, and it will be up to the person to prove the lawful origin of their property. So if we really take them in their purest form, unexplained wealth orders entail a reversal of the burden of proof outside of the criminal judicial system to target criminal property. And that is an increasingly looked at power as well. So you see, it's what I call a slippery slope from standard confiscation to extended non-conviction based confiscation, but we're seeing that evolve as well at a EU level. So having said that, having explained a bit the different models that I see at EU level, at EU member states level, sorry, I will now talk about the latest EU legislation on asset recovery, and with focusing on confiscation, and try to make a comparison between what we have in that transversal typology and what we see here. So you have a number of legal instruments at EU level targeting freezing and confiscation of assets. I'll already say that I will not go in depth into all the slides. I will pass some of them. I just wanted you to have the most comprehensive PowerPoint possible, so that if you want to go back to it later on to have more information, you have something quite comprehensive. So there was a number of council framework decisions dealing with confiscation and freezing of assets, and lately the EU has decided to reinforce the legal framework on freezing and confiscation by adopting first a directive and then a regulation. So starting with the directive is substantive law because the idea of the directive is to harmonize confiscation models. So try to have some overarching models that are replicated and implemented in every single member state. So it's aimed at improving domestic powers of freezing and confiscation. Then you have procedural law, the regulation, the new regulation that aims at increasing the mutual recognition of freezing and confiscation orders. And the aim is to improve cross-border enforcement of freezing and confiscation order. So basically, the 2018 regulation helps complements the 2014 directive to try to have a more effective asset recovery in the EU through more cooperation as well. So substantive rules for freezing and confiscation, the directive, I will not go into that slides. I give you some of the recitals explaining the underlying rationale of the directive and on the need to implement those powers. But I will not go through the whole articles. You here have the table of contents of the directive. I will just talk about extended confiscation and non-conviction, what is supposed to be non-conviction-based confiscation within criminal proceedings at EU level. So first, as I was saying earlier on, the EU wanted to implement to some extent a non-conviction-based model of confiscation. In the end, that did not happen because what some refer to as non-conviction-based confiscation in Article 4.2 of the directive is not what I explained to you. It's kind of a hybrid model between conviction-based and non-conviction-based confiscation. So basically what we have at EU level under Article 4.2 is that it should be possible for member states to order confiscation without the conviction of the offender, provided that criminal proceedings have been initiated against that person. So basically you have to start the criminal route, go before criminal court, try to prosecute that person, and where that person is ill or absconding, you should be able to still, and you don't have in absentia proceedings in your jurisdiction, you should still be able to take away that property without having to convict them. So it's not a true non-conviction based model. You don't go through civil proceedings. You don't benefit from the civil standard of proof, but it's confiscation without criminal conviction within the scope of criminal proceedings. Note, however, that the EU is actively working on whether or not they should implement a non-conviction-based confiscation model. There's an analysis of April 2019 that was released discussing the question again. So we might see non-conviction-based confiscation being tried to be implemented in the future at EU level. Then you have harmonizing extended confiscation. So I explained already to you what extended confiscation is. Just note that before the directive, there was already the framework decision 25 that asked member states to implement an extended confiscation regime, but the EU was allowing to cherry pick between three regimes. So it led to really different concepts in national orders, no harmonization, and so challenges in cross-border cooperation. It was inefficient. So the 2014 directive imposed one model of extended confiscation on member states that they have been implementing. Again, I will not go into all the recitals. You're free to read them at a later point. Just one word. Also, sorry, the title of the slide is wrong. It should be third-party confiscation. So third-party confiscation should also be available with malafide parties or persons who should have known that the property they received was of unlawful origin or were criminal tainted. So implementation of Directive 2014 and beyond. So I was referring to a 2019 analysis of the European Commission. They actually made statistics on what models were used at EU level. So according to that report, 25 member states rely on what they call non-conviction-based confiscation within criminal proceedings. So what I just explained to you within the scope of directive, which is not a true form of non-conviction-based confiscation. 26 members have extended confiscation within their domestic order, and what is more interesting, 13 member states also have some form of true non-conviction-based confiscation. So I was explaining to you either civil confiscation or unexplained wealth holders. So non-conviction-based confiscation is really spreading across the EU. Almost half of its members have such a regime. So the last part is procedural rules for mutual recognition of freezing and confiscation orders, because now we have a more harmonized EU confiscation law system. But still, you have to be able to enforce cross-border orders, because generally high crime is not one jurisdiction crime. So there's criminal engineering. Criminals are quite sophisticated, and they will use a lot of member states to do their criminal activities, because this will complicate their repression. So today, here are the two framework decisions that are applicable within the scope of executing foreign EU freezing and confiscation orders. Basically, Council Framework Decision 2003 establishes rules for the recognition and execution by a member state of a freezing order issued by the judicial authority of another member state in criminal proceedings, with a view to separating confiscation. So basically, for instance, if I'm in Belgium and I know that there's criminal property of the person I'm being investigating in France, I will send a certificate in France to ask for that property to be seized and frozen in France. And that's basically what you're going to use as an instrument. Then you have the Council Framework Decision 2006 on confiscation. That's a bit the same idea. If you have convicted a person and you have ordered confiscation, you want to enforce that order. Again, if I know that that person has property in Spain, I will send a certificate to Spain and ask them to confiscate that property, with a view to enforcing the Belgian judgment. So the issue that we have here is that the European Commission has observed that there was a lack of application of these instruments by member states. And again, that's explained in the recitals, which I will not go too much into detail. But basically, what they say, look at the second recital that I'm putting here, is that the existing regime for the mutual recognition of freezing and confiscation orders is not fully effective. The current instruments have not been implemented and applied uniformly in the member states, leading to insufficient mutual recognition and suboptimal cross-border cooperation. So basically, we do have two instruments, but it doesn't work. That's what the Commission is saying. So, and they're giving good examples of why it's not effective and working. Examples. While France is able to execute Italian non-conviction-based confiscation orders under mutual legal assistance, Spain would systematically deny the execution of a civil non-conviction-based confiscation order taken using in rem proceedings. For example, Ireland may issue a civil non-conviction-based confiscation for criminal assets located in Spain when a criminal conviction is not possible. However, as Spain does not recognize such Irish order, the property order could not be confiscated and would remain at the offender's disposal. So what you see basically is what I explained to you. There's a lot of different confiscation powers that exist in the EU. And if you don't have mutual recognition system that obliges you to recognize the orders from other member states, you might want not to do it if you don't really understand what we're talking about. What is the confiscation order that was issued in that other country? So what the Commission decided to do is to create a regulation to make more effective the mutual recognition of freezing orders and confiscation orders. Basically, it will be applicable throughout the EU as at the end of this year, so from 19 December 2020. I had the privilege to give a training last November at the European Commission to experts on confiscation of each domestic order because they're starting to try to create some awareness at the EU member level to be sure that they will apply that regulation as soon as it becomes into force. So basically what that regulation does, it simplifies and it strengthens the applicable legal framework. What is really interesting is first, it's one single instrument to target both freezing and confiscation, whereas it was in two different council frameworks before. Second, it's directly applicable in all member states. There's no need to transpose it. And it's the first EU regulation in the field of mutual recognition in criminal matters since the entry into force of the Lisbon Treaty. That's very important because that shows how much they wanted a direct implementation of that regulation to have it more effective. A few words, I will not cover everything because I'm running out of time, but I will focus on a few points. What I think is really important is that regulation widens the scope of cross-border recognition. It applies to all orders issued within the framework of proceedings in criminal matters. So there's a lot of legal debate on the meaning of that scope. It's the result of a lot of EU talks to be sure to cover enough models of confiscation. I will not go into details, but there's debate on that. Basically, what it means is that this regulation covers all the orders covered by Directive 2014, so there's really a parallel there, but it also covers more. It covers other types of orders issued without final conviction, excluding further to proceedings in administrative and civil matters. So basically, it will apply to Italian confisca di prevenzione, the non-conviction-based model in Italy, but it will not apply to the UK or Irish civil recovery models. The idea is increase of speed and efficiency, and I will just go to that, I think, to end up. What is interesting is that the aim is to have it work more efficiently. So basically, freezing orders will now have to be transmitted by means of a freezing certificate. There's a standard certificate in the regulation that all member states will use. So when you receive it, you know what it is about because you have the same model at home. Same thing for confiscation. There's a single standard confiscation enforcement request that everybody will have to use, and the issuing authority will have to provide the executing authority with a translation of the order in an official language of the executing state to be sure that things are really effective. Lastly, whereas the framework decision didn't do it, now there are clear deadlines for freezing and confiscation orders. So the executing state who received the request to freeze or confiscate has to do it for freezing without delay. And if there's legitimate grounds to believe that the property will be removed or destroyed imminently, then the decision has to be made within 48 hours, which is a very short and precise term. For confiscation, the decision on the recognition and execution of the order has to be taken no later than 45 days after receiving the confiscation request. So that's basically it. I hope this will bring you some interesting information about the evolution of the asset recovery legislation in the EU, and I'm obviously available for questions. Thank you very much for your attention.